All right. Well, thank you again for joining our Resolving SpaceTech Disputes. My name is David Earnest. I'm a co-moderator and co-founder of ArbTech, which is the organization sponsoring today's talk. I'm working on the presumption that all of you here today are familiar with ArbTech, but if not, you can always find out more information about the organization on our website, arbtech.io. And of course, you can follow us on LinkedIn and Twitter. I wouldn't even call amateur, I'll call myself a space enthusiast and also a disputes lawyer. So I have to say I am particularly fascinated and excited about today's discussion. I'm even more excited to be joined by two leading experts on disputes in all things space that we have here today. First is Dr. Gérardine Escolar. She is a professor of the Faculty of Law at the National University of Singapore. She's also an academic fellow at the Center for Technology, Robotics, and Artificial Intelligence and Law, also at the National University of Singapore. Professor Escolar is also the Deputy Secretary General of the Hague Conference in Private International Law. I'm also joined by Viva Dadwal. Viva is an associate at King & Spalding's New York office and a member of the international arbitration practice with that firm. Her practice involves commercial and investment treaty arbitrations, as well as enforcement proceedings before U.S. courts. Viva co-leads the research project on space-related disputes at McGill University's Institute of Air and Space Law. As mentioned at the top of this discussion, please insert any questions you have into the text chat box. And to the extent our speakers can, we deal with them during the discussion. Otherwise, we have reserved a question and answer session at the end. With that, I'll turn it over to our two speakers today. Thank you very much.
Thank you, David, and thank you, Sean, and thank you, ArbTech, for having us. The way in which I think we're going to work today is I will briefly, introduce the topic. And following that, we'll go into a sort of question and answer with Professor Escolar. As was mentioned, I'm an associate at King & Spalding. I'm interested in space-related disputes, and today's discussion is really focusing on kind of the overlap between space and technology and arbitration. So it's very interesting conceptually, because usually I only think about space and arbitration, and now there's a technology component. And so what is space, what we are calling space tech, what does space tech mean in the context of ArbTech, which is this group, right? And so we understand that, this group has been around, and everyone here is in some way or another interested about the future of justice, about the future of technology, new and emerging technologies. And so with the rise of the space industry and the proliferation of the space actors that we are seeing, as well as new space, we think that there are, the technologies that we will that will emerge, that will develop, will raise new questions at the intersection of space, technology, and dispute resolution. And so it'll be very interesting to have this discussion to kind of expand ourselves beyond the territorial limits, as the title says. And we expect there'll be new ways in which we do arbitration. There'll be new ways of doing the law on space technology and space disputes and tech disputes, as well as procedure, as we extend beyond the limits. So, the reason why this matters, I would say, is one, growing actors and stakeholders. Two, it's a growing industry. And three, I think there are opportunities for growing laws and policies in this area. And so that makes it very interesting for the arbitration community. And I think, in order to have effective dispute resolution, we need to pay attention. We need to track the development of this law, of the law as it emerges, and we need to participate in it. So, so that's just a little bit of background. I think we could probably turn to just my own research and my own interest in this field. About, I think it was 2019, I was interested in just, understanding more about this area. I had actually taken a course with Professor Go Escolar, which is how I was introduced to space law. I was on exchange in Singapore, and that turned me on to, researching what space-related disputes might entail. Turns out in 2010, the PCA, the Permanent Court of Arbitration, had thought about this. Lots of scholars, practitioners had participated in developing rules for dispute resolution of disputes involving outer space components. And so I was interested in looking into what the status was of space-related disputes. And that research has kind of launched my journey into this area. And so it's a pleasure to actually be asking Professor Go Escolar lots of questions today, because it's been a while since 2019. So what we did was we surveyed, just tried to look at publicly how many, what is a space-related dispute, and to try to get a snapshot of what was out there. And what we found was that there are disputes. A lot of them are resolved amicably. They might be going to courts. And most are resolved behind closed doors. And so trying to get that research and trying to just go out and get examples of what's out there was an interesting journey. So yeah, basically just took search terms, went into kind of, and this is where I do think there's a role for ArbTech, took search terms, went into Mundi, went into Westlaw, the databases, and just ran searches and tried to see what we would find. And then tried to categorize it manually to try to understand this area a little bit more. Disputes mostly focused on the satellite sector. It's a mature industry. And the topics were actually surprisingly Earth-based, I guess is the best way to put it. They were very territorial, which is where I don't think we'll be going today. But turns out, you have lease of spectrum rights and orbital slots, you've manufacturing, sale, and purchase contracts, you've got technical failures happening, you have different commercial arrangements, you have space insurance, lease of capacity, launch and delivery of a satellite into orbit. So lots of things that could just be resolved through a contract. And so the outer space component, you would just look to the contract and you would say, well, how did the parties want to resolve their disputes? We didn't find that we were pushing the limits of territoriality as we're talking about hopefully today. So those were kind of the outcomes of that research, where most things were being resolved as business as usual, and they were going to the usual places where you would expect disputes to be resolved: the ICC, the LCIA, and most disputes, as I mentioned, were commercial. So that was very interesting, just in terms of insights, because what we were finding is that we don't have outer space disputes a la outer space. There's a pretty strong connection to territorial limits and applicable laws and the forum as well. So I think with that, I can also briefly just talk about just another kind of research project, just on kind of the needs of users as well. And having surveyed a few individuals, just getting their insights into what are the needs of users in this industry, turns out users do need kind of the generic kind of confidentiality and expertise and speed. And so that was also an interesting insight because, and it makes sense because the disputes that we were seeing were kind of traditional disputes. And so confidentiality was important, technical expertise was important, timelines were important, of course, as you can imagine in the space sector. But what was really interesting was we were learning that the majority of survey respondents who we had surveyed were also thinking that these types of disputes would happen more likely in the future. And so, I think we're at the stage now where I'm interested in hearing Professor Escolar's thoughts, where we know where things were before, but now we have kind of the injection of technology into this. And so space-related disputes, as we've seen them before, were kind of territorial and commercial insofar as they're linked to kind of applicable laws and specific forums. And they're kind of like any other dispute that you would find that's resolved through a contract. And so hopefully we can pivot to some of the ways in which, space technology will look differently, and when it's introduced, it'll be a little bit different than what my research had shown. And so what I've done is, what I'm hoping to do with this group is also to share with you, if to the extent you're not familiar with, one of the most fundamental treaties, the Outer Space Treaty. And so I'm hoping to use and explore the question of future space technology disputes and how they might compare to kind of the more space-related disputes that are contractual commercial disputes that we've seen to date. And so what I will do is I'll just share a snapshot of kind of key provisions of the Outer Space Treaty. And just as background, Outer Space Treaty signed at a very interesting time, 1967, product of the Cold War. And I think international space law, and Professor, feel free to chime in, but it's a relatively new field of international law. It's not been around that long. And so we'll see how it lasts as we go forward. And a lot of people would argue that it's done quite well. Of course, some people have issues, and certainly commercial actors need more stability, but hopefully you'll see kind of the questions that come up as we look at this kind of really, well, it's not that old, but it's from 1967, this instrument, which is one of the main treaties, as we kind of go through the questions of tech and space and dispute resolution specifically. So Professor, unless you have any other comments, I think I'll move to sharing just the snapshots.
Yeah, thank you very much, Viva. And thank you very much to David, Sean, and ArbTech for having me today. I think Viva's given a very good exposition of the conversation we're going to have today. Perhaps if we take one step back, when we're looking at ArbTech and we're looking at tech and why we're arbitrating, we're facing two, I think, components here, right? One is arbitration, which is part of a whole spectrum of dispute settlement mechanisms, and the other is technology. And you kind of figure when you talk about space that would be the thing that we're talking about, the high ground, the theater, which any sort of dispute will affect everything on Earth, everything literally, because it's something that envelopes the entire planet. And space is, I suppose, the final frontier. So when we're talking about technology, that's where we're at, is the cutting edge. It's basically from 67 till today in 2023, the things that we set up in space are at the cutting edge of technology. So when we put those two together, I think, space technology and the resolution of space disputes, whether through arbitration in particular or around arbitration, really is something that, in my opinion at least, should be something in the middle of what ArbTech actually does look at. So I'm really pleased that there is some interest with that. Now, Viva very humbly talked about the research and was very modest about it. That research is actually part, I think she published it as a paper, which was presented to the colloquium of the International Institute of Space Law in 2020. And I think it's called Arbitration of Space-Related Disputes. And there, what she's done with, I think, Ms. Madeleine MacDonald, was to talk about the case trends and analysis in relation to the resolution of space-related disputes. So they categorically catalog and analyze all publicly reported space-related disputes. And Viva knows this better, of course, but this is what I understand it to be. This is a very interesting compendium because it does put together everything we know on the public record of space-related disputes that were submitted to international arbitration, so specifically international arbitration, and they organize it by industry and by topics, focusing on things like type and subject matter of disputes, the kinds of disputants, the type and sizes of actors, the applicable law, preferred seats in arbitral institutions. Now, what's really, of course, interesting about this whole research is that it provides an interesting snapshot on what is actually commercial space. I mean, so commercial space industry, what also some people call the new space industry. You will then have heard Viva approximately 3 minutes ago talk about something called the Outer Space Treaty. And those two worlds seem to be completely separate. So we're talking about contractual disputes and disputes about whether you deliver a transponder that works well or not, whether you have actually properly fulfilled your contractual obligations. That seems quite far away from public law and quite far away from public international law. So why are we talking about this 1967 Outer Space Treaty? We're going to go to that in a moment when Viva starts showing all these slides about what's going on. But again, as she said, we need to keep in mind that we're in 2023. This is a treaty that dates from 1967, but it does have the majority of countries in the world that are signatory and parties to the space treaty. And there is something in public international law that is dear to all public international lawyers. The norms in this treaty are what we consider to be customary international law. The specific significance of that being that if it were custom, if it actually is custom, it binds everybody regardless of whether that state is contracting to the space treaty or not. Now, the treaty has gone on since 1967. There has not been a particular allegation of a violation of this treaty so far. That's not to say it hasn't been violated, but there hasn't been a public allegation of a violation of that treaty. So this is something that is quite important. When we're looking at the various different provisions today, these are the ones where interpretation is an issue, where negotiations at the United Nations are still ongoing. And so this is something that is a live issue. Now, the other thing, of course, is that Viva's done a fantastic job with her colleague, Madeleine McDonald, in relation to looking to disputes which are publicly available. Many of these disputes are not publicly available, one of the wonderful things about arbitration. And of course, in particular, due to the particular nature of space activities and how high security some of these things are, the kind of theater that we're looking at, and the strategic importance of some of these issues, quite a lot of these disputes never see light of day. And I think it's also then important to keep in mind that, interestingly, perhaps not so interestingly to this crowd, but arbitration is the method of choice in terms of resolutions of disputes for the vast majority of public institutions that are active in space. So when you look at the European Space Agency, for example, their choice usually is to go directly to arbitration. So they try to resolve it, of course, with negotiation among the technical staff. If it doesn't work, it always escalates towards arbitration. There is only one agency in the world that has chosen not to go to arbitration, but to go directly into litigation and adjudication. And that's basically the ArbSat, basically. So that's the only one. The rest of them have chosen arbitration. And for that reason, it's also important to think about the public law aspects and how that impacts on commercial space and on commercial activities in outer space and the resolution of those disputes. So I think that's just maybe introductory wise to set the context. That might be something interesting. And as Viva says, I think it'd be good to maybe just kind of turn to the conversation that we hope to have today.
And just to add to that, I think there is, and I should clarify, right? So you've got the international treaties that are a layer. And then below that, of course, states are implementing those treaties. And so you've got a framework of national laws. And then, of course, you've got parties, private parties or public parties entering into their contracts. So you've got different layers of law that might apply that all stem from the international. But of course, as this conversation hopefully will demonstrate, there are, at the bottom of that, where there are private parties entering into contracts with each other, you might see them push up against the limits of international law, and all three kind of have to exist harmoniously. But it's very interesting to see how something in 1967 might now interact with parties entering into contracts with respect to whatever their commercial space activities might be, or even public activities for that matter. And so it'll be interesting to explore that, because there's that conversation from kind of the macro to the micro that needs to kind of keep happening, which makes this field, again, very interesting in my opinion. So let me share my screen and we can just share, for those who don't have a background in this, we'd like to explore this question of hopefully, sorry, just making sure. The way in which future space technology disputes may compare to space-related disputes, some of the more traditional disputes. We're hoping to kind of walk through some of the underlying fundamental principles from the Outer Space Treaty and then explore them in conversation. So this on the screen, hopefully you can see it, these are they're snapshots. It's not always complete, but so the Outer Space Treaty says, just with respect to property rights, and that's an interesting way to start. It says that outer space is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. And then later on in Article, so that's Article 2, and then Article 8 will say, which is actually the registration part of the article, but what I found interesting was also it talks about how ownership of objects launched into outer space, that ownership is not affected by their presence in outer space. So here's something where the drafters of the treaty have already thought about kind of pushing the limits of international law, whereas usually you won't have that kind of tether. Here you have an intentional tether between whatever is launched from Earth to outer space as having that nationality, which I think is very interesting, and the first kind of example that I'm hoping to talk about. So Professor Escolar, do you think that space technology disputes, you're looking at property rights in space and you're looking at the international kind of framework, and you see it says not subject to national appropriation, ownership is not affected by the fact that you're in space. Do you think that space technology disputes will have the same reference point for property rights as we are seeing in international space law?
That's a really good question, Viva. I see you have a slide immediately after. If you wouldn't mind, it might be helpful to just go to Article 6 first. It's a bit out of step in terms of the numbering of the treaty, but it might be helpful to kind of understand why we're talking about whether it matters what a state does. So Viva's right, the Outer Space Treaty is an international treaty under the auspices of the United Nations. It means that to be party to this treaty, a party to have standing to become a party to this treaty must be a state, usually a member of the United Nations. So these are countries. These are all countries which are recognized as states before the UN. They sign this treaty, they ratify it, they accede to it, and they become contracting parties to it. Now, that's what the state does. So you might ask the question, why does it matter what the state does? If a private commercial entity which has no ties to the state does something else, why should it matter what that state does? And it all ties back to Article 6 of the Outer Space Treaty. Now, this is quite particular. We'll come back to it when we talk about certain types of technology, which is autonomous. But in most cases in international law, in order for a state to be responsible for something, the act needs to be attributed to the state. So you need to attribute that to a state. Now, of course, there are different acts that a state could do, and the very Latin way of referring to it is acts iure imperii. These are basically acts that only states can do. So only a state can enter into a state of war. You and I can have a dispute, but we cannot actually enter into a war with each other. Only a state can send a diplomat. I can go on vacation, but I cannot declare myself the ambassador of myself to a country. Those are specific sovereign acts that only states can do. On the other hand, there are also acts which are called acta iure gestionis, and those are commercial type acts which a state could do. So, for example, to run a government, I might need pencils, and so I send out a procurement contract for pencils. As private individual, I can also walk into a shop and buy pencils. So that's a category of things which are more commercial, more private, which a state can do, but which a private entity can also do. Now, the categorization between these two kinds of activities is how international law attributes certain things, which gives responsibilities to states. Space law is one of the only fields of international law where this veil between the two categories of activities does not exist. And this is by virtue of Article 6, and you see it before you on the screen, where it says the states parties to that treaty shall bear international responsibility for national activities in space. And then it carries on a little later that says whether such activities are carried on by governmental agencies or by non-governmental entities. So as long as that entity has nationality, so belongs to a state, the state is responsible for such activity. Now, this is important to understand why this whole framework does apply to space activities. Otherwise, we wouldn't much care, really, in a commercial context. Now, I'm going to ask Viva, if she wouldn't mind, to then move forward to the slide that shows Article 7, which I think is the next slide. And when you see that on your screen, you will see that basically it says there that in terms of liability, each state party to the treaty that launches or procures the launching of an object into outer space, and each state party from whose territory or facility an object is launched is internationally liable for damage. Now, this is interesting because also in international law, a state is never considered liable. It's only considered responsible for something, meaning that the responsibility arises at the point of time an internationally wrongful act occurs. So before the wrongful act occurs, there is no responsibility. The moment a wrongful act occurs, that's when responsibility happens. And then states usually have the responsibility to reparate that damage, may not be liability for damages, but reparate, so make good on any sort of wrongful act that has happened. Space, again, is different. It does have a specific article that focuses on liability for damage caused. So this is something important. The state itself is internationally liable for damage caused. And of course, it is also responsible for any kind of activities, even if it's carried on by a non-governmental entity. So, for example, if I were a national of state X and I procure the launch of a space object into outer space by myself with my own cash, it goes into outer space and I don't take care of it and it smashes into a satellite of a country of, say, state Y, my state is internationally responsible for the activity I undertook personally as a private individual. That's basically the kind of a 101 for it. Now, if we can then move back, sorry, Viva, for this, to go back to Article 2 and your original question on the matter of property rights. And again, forgive me, if we kind of look back as to how property rights are given. Now, you and I can, of course, go and decide to buy a piece of land on which we would like to build a house. And what we would do, of course, is go check out who owns this piece of land, pay that person or that entity some sum of money. There'll be I suppose, a transfer of deed at some point. It'll be registered somewhere, and I will become the owner of that land. But how did the person before me have rights to that land? And how did the person before that have rights to the land? And usually, this is given by sovereign act of the state. In a common law country, it could, of course, be in perpetuity. It could basically be something forever. It could have also be a leasehold of a certain number of years. There are various different kinds of easements and so on. But it generally, when you trace it all the way back, it goes back to a right that a sovereign, as sovereign power over that territory, gives to a private individual or entity. There are very few, if any at all, cases of property rights that do not emanate from a sovereign. And generally, what happens then is something called the claiming of something called terra nullius, where that land belongs to no one, so terra nullius. But even then, it's generally claimed in at least the history of Earth on behalf of a sovereign. So in the age of exploration, we had all these explorers going out. Of course, at the time, it did not matter that those lands actually were inhabited, but what they did was just planted a flag there and said, hey, I claim this on behalf of king or queen, so-and-so from whichever country it is. So when we have that in mind, that's how most of our property law today comes from. So it comes from this idea that a sovereign gives these property rights to private individuals. Now, interestingly, of course, in 1957 to 67, when this treaty was negotiated, what was happening in the 50s and 60s, decolonization was happening, was past the Second World War. There was all these emerging economies and many, many more entities that have become states. And then, of course, the question of outer space. For the first time, in principle, infinite, in principle, abundant. And out of one of the wonderful things that came out of the Second World War was the idealism that this was not, this whole, plundering and taking resources from others and so on was not going to happen again, and should not happen and should not need to happen because of the abundance of outer space. There's so much of it. So, there's no need to go and stake my flag on it and claim it. And in fact, it should be for the common benefit of all humanity. At the time, it's called all mankind. Today, we call it all humanity. And so Article 2, outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. And of course, the corollary from that, according to many states and many scholars, is that, therefore, since there's no national appropriation of anything solid or material in outer space, there is also therefore no property rights. Meaning, those wonderful websites and companies that sell you pieces or tracts of land on the moon, that's as good as a piece of paper is printed on, essentially. I mean, and I also have a really good apartment overlooking Brooklyn, if you'd like to buy that. So that's actually property rights. Now, of course, we do have certain questions. So, for example, on the high seas on Earth, the high seas are also not subject to national appropriation. They are high seas, so they're not territorial waters. But we do have fishing boats that do go out to the high seas. They do put their fishing lines down or their nets down, and they do get the fish out. They sell that fish for profit. So the question then, of course, arises: what happens if I'm not claiming the moon or the celestial bodies? But what I do is I go there and I mine it. Say the vast amounts of helium-3 on the moon, there are certain rare metals, oxygen, on various different asteroids and near-Earth objects. Say I go and I mine them, and I don't claim the thing at all, but I take the resources. Can I use that? Do I have rights over that? And of course, there's a split down the middle now. There are some countries that do believe, yes, the analogy is the high seas, and yeah, of course, you take that resources. It does not mean that you are claiming appropriation or sovereignty over that body, but you're removing the resources, and from there you can use it. There's still a body of people who believe the opposite, saying, well, if there's no claim of national appropriation, then you can't also do something like that. Now, if you look at the two articles two provisions that are on screen right now, the first one is Article 2, and the second one is Article 8. And here's also important to make a distinction, as Viva will probably elaborate upon. It is different when we're talking about natural resources in outer space, so things that occur naturally, and things which are man-made and launched into outer space. If things are man-made and launched into outer space, then ownership falls to the person or the entity that has registered it on the national register. So registration gives jurisdiction over that the item, and that the ownership is not then affected by the launch into outer space in the presence thereof. That's, however, different. So a different regime applies to man-made objects launched as opposed to natural objects that already exist in outer space. Viva, perhaps you have something else to add to that?
Well, the only thing I would add is, what about digital? We think about digital assets in space. How does that fit into, you've got your natural objects in space, you've got your man-made objects in space, and it's pretty clear where property will go. One says, like you said, right, states cannot appropriate space, but private actors might be able to. And then with respect to objects that are launched into space, it's fairly clear. But what about digital assets in space? What about, and then of course, like at some point there's disputes relating to, and I know, perhaps you can share a little bit about kind of that field and the companies that might be operating in that. So as we are seeing space companies go out, there's also a lot of reliance on tech companies operating with space companies, right? And space companies using technology, and the way in which we think about property rights, being pushed. So could you share a little bit more about, that digital realm in space?
Sure, no, absolutely. It's a great question, Viva. I think perhaps the best way to talk about an actual use case. So the thing that gets a lot of attention, has gotten a lot of attention in the last few recent months, is blockchain technology. There are two ways of looking at blockchain. So the obvious one, whenever I say blockchain, immediately everybody jumps directly into cryptocurrency. So let's deal with that one first, cryptocurrency, Bitcoin, and that sort of thing. That's an interesting case because there have been companies, Space Chain is one of them, and the idea is to launch a constellation of satellites, so man-made objects, satellites into outer space, in a constellation in low Earth orbit, and to have cold wallets installed on each of these satellites. So a cold wallet is a wallet that holds this cryptocurrency and is not connected to a network. So it's kind of like a storage for this sort of thing. And it's interesting because it makes use of exactly this question on the registry. So when you have a satellite, the state party that has that satellite on its national registry is the one that has jurisdiction and control over that satellite. All right, meaning that if I have a cold wallet on a satellite that's registered to a certain jurisdiction, it could be, for example, for tax planning purposes, it could be for various different other purposes, or it could be for a forum that has legislation and regulations which are friendlier to cryptocurrency. That's one way to use it. So essentially you put all these cold wallets and you have a system that's in outer space, and therefore by this regime, you can actually pick and choose the forum that you want for your jurisdiction, for your applicable law, and so on. So that's one way to use it. Now, the other part of the digital assets thing is this thing that is referred to as digital twins. So imagine that you have, just to say, for lack of a let's say a near Earth object, so an asteroid, one with rare metals on board. And we do know that this asteroid goes in a particular orbit in the solar system. We can track that asteroid. We know an approximate amount of its mass. We know how big it is. We know the approximate percentage of that mass in terms of the rare metals that it has. Now, also assume that we have then the technology, which we actually now do, to capture that asteroid, or to at least land on the asteroid. And soon in the future, we will have the technology to mine it and perhaps to return or manufacture with the resources extracted from that asteroid. That in itself could become a security. So what happens? We know that there is something of value on that asteroid, and what we do is simply make a token of it. It could be a non-fungible token. It could be any kind of other digital asset, digital kind of token. And we can use that token either in secured transactions or as a security, or simply as a thing to barter with. The question then, of course, is that if a dispute does arise in relation to the digital holding, so the token or the asset that's been digitized, what applicable law would we use? Which state would have jurisdiction? Where would the forum be? Would it be entirely up to party autonomy to choose the forum and to choose the method of dispute settlement? Or how would that work? And I think that's one of the questions that when you see the intersection, at least, of space technology and all the digital realm, that's actually quite interesting from an academic point of view, actually seeing two worlds from opposite ends collide. So we have the decentralization of all of these distributed technology and all of these very disintermediated kind of technologies, which want not to be regulated. And you have the very hyper-regulated environment of space where everything can be attributed back to the responsibility of the state. And when these two technologies collide, the question basically is, for disputes settlement and for arbitrators, what's going to happen? Do we use the regulation of the state party? Do we talk about the decentralization and the disintermediation? Can we do that? What if the nodes are not cold? What if they're a hot wallet and these are distributed in ledgers that span the entire globe? How do we pick the jurisdiction that is the most appropriate? Should we just let the parties choose? How do we protect weaker parties where no choice has been made, for example? So I think all these are questions that probably would arise. Some of them are being, of course, discussed in different fora, and I don't think we've come to an answer yet.
This is very interesting, and we've talked already about. So let's also be mindful of the time. So we've already talked about. So there's, obviously, lots to do in this, but just turning back to kind of the responsibility and liability aspects of, operating in space and having activities that have an outer space component. And do you think that, when we're dealing with these digital assets and digital property in space, that this mechanism, right? So there is the private international law way of resolving disputes. Let's find a contract, let's agree, let's set out the applicable law and kind of the easier kind of, I think, approach. But you've also got the state involved here. Now, the state need not be involved, because if it's privately going to resolve, it's going to be privately, resolved. But do you think that this, what's before us in terms of responsibility, in terms of liability, these conceptions of, state centeredness will have to evolve given the types of technologies that we will see and are seeing in space, including kind of the digital kind of influence in space as well?
Oh yes, and I think they not just have to evolve, but they have evolved. And not just based on the technology, but also in particular based on how disputes are resolved. So for example, when we're looking at a lot of these states who are aware that their nationals are undertaking space activity, whether it's commercial, well, firstly, I think we need to probably say that there are a lot of what's considered commercial private enterprise has some link to a government somewhere. So, for example, SpaceX is one of the biggest, private entities that we know are involved in space. They've done very well in terms of getting commercial space off the ground. But the biggest the biggest contractor is with NASA. So, all the money does have some sort of link to a public fund. Not all enterprises are linked to the government, but quite a large majority of them still are. So that's one thing. Now, there's also a lot of public-private partnerships. So the government or some governmental entity is still involved. But even in the case where it's not, because of Article 6 and Article 7 of the Outer Space Treaty and the attendant liability convention, so there's an entire convention that was agreed in 1972 that lays out how liability would be done, including a claims commission, and aware that a lot of these disputes go into arbitration, many countries have undergone legislative reform to include things like indemnification and the necessity for insurance, certification, authorization, and licensing. To make sure that the state is aware of what's happening, so that they're not caught flat-footed when a dispute does arise. And let's be quite honest, when people go to dispute settlement, what they try and do as well is to get recompense for damage that has occurred, which means that you're not going to sue the person that you know cannot compensate. You're going to sue the deepest pocket. So where there's no insurance, the state generally has to indemnify. And that's what usually has happened. So there has been already this evolution. When we're talking about digital assets, I think it's going to probably be even more. Now, the question is whether the legislative reform will take the perspective of the digital assets or from the space point of view. And I think there will be an interesting tension because...
I'm not able to hear you. I hope others can hear you still.
Can you hear me now?
Just got cut off.
Oh, dear. Can you hear me now?
We can still hear.
Yeah, on my end.
That's perfect. Okay. Tell me if you have any more audio issues, and I'm going to try and fix it from here. But can you hear me now?
Are others having trouble hearing the professor?
No, Viva, we can hear Professor go.
I think it might just be on my end. All right, okay. I will figure that out. Please continue.
Oh, thank you. So I think like the tension will simply be whether the legislative reform focuses from the digital assets point of view or from the space sector point of view. And I think that will be an interesting thing for states to consider, because the theater of outer space, with its strategic and military importance, as well as its political considerations, is something that I think few states will be loath to give up, I think. So it's something that they must consider regulatory-wise, let's say. I think Viva's probably still having some audio issues with me. So I think if that's okay, I'll just kind of talk about the slide that's on the screen right now. And that's Article 7 of the Outer Space Treaty. And there you see, it's quite interesting, the matter of the object that has been launched into outer space. So it does say there that the state party that launches or procures the launching of an object, or the state party from whose territory or facility an object is launched, is internationally liable for damage. For damage to another state party or to its natural or juridical persons by such object or its component parts. And that's on the Earth, in airspace, or in outer space. That actually has a very wide catchment area. So we're talking about 4 different categories of states that could be liable for the damage: the one that launches, the one that procures the launch, the one from whose territory it is launched, and the one from whose facility it is launched. And that's to get as wide as possible, because back in '67, of course, outer space was considered to be an ultra-hazardous activity. So if you do anything in outer space, they're all ultra-hazardous. And it was a very victim-oriented approach to make sure that there is somebody you could bring before a dispute settlement body in case anything did happen. Again, as I mentioned, from the 1972 Liability Convention, there is a whole framework set out so that states parties are aware of how the liability can be apportioned. There are also certain rules on joint and severable liability. And what happens if an international organization is also involved. So it's a very public view on this, but the idea then was always that there would be a public institution who could be liable for any damage caused in the case it actually did happen on Earth, in airspace or outer space. Now, you see that the highlighted part, the bottom of it, that does refer to object or its component parts. And that's basically in the case of where there's a breakup of the space object. Today, that particular significance of that clause is because of the space debris issue. So there are lots of non-functioning space objects in orbit around the Earth, in particular in low Earth orbit. Most of them are tracked, the bigger pieces, the little pieces are not. But there is also a concern of something called the Kessler effect, where these objects are orbiting at extremely high speeds around the Earth. And when they collide, they create more debris of smaller pieces. And these smaller pieces, again, go quicker and quicker around the Earth. And so you end up with a cloud of debris in some of the most populated orbits around the Earth, which then, of course, creates even more, an even higher risk of collision. The issue, of course, is how to attribute the damage. So if you have a piece of paint, for example, that has torn a solar sail, for example, how do you know where that piece of paint came from? I think the attribution is an issue. But on top of which, I think the important thing is that this refers specifically to damage on the Earth in airspace or outer space, which means that it refers to physical damage. And this might have an impact on the digital assets point of view, where there is, say, monetary or future damages that does not come under the Article 7 or the Liability Convention. I'm very happy to see Viva nodding because she agrees with me, but also that means she can hear me. So,
yes,
it's
good that we're talking about space and digital, the pushing technology, and yes, I still have technical issues. Just on this point, and I'm mindful of the time as well, but I do have to ask you, a lot of space companies are also using artificial intelligence. There's a lot of open source software being used. How do you think AI will impact kind of just this paradigm that we've got, right? Do you think states are, can they be held responsible for AI in space and the use of AI in space?
That's a brilliant question, really. I mean, so today, the biggest news in the last 2 weeks is ChatGPT, and all these large language modules. They can come up with information that could be correct, information that could be misinformation. Apparently talk about love and how afraid it is because it cannot remember what it said before, and all of that, basically. But it came from a private entity. So this was coded by a private entity. The idea was it would trawl the internet, learn from that, and then come with a lifelike response to certain questions. The particular question when it comes to artificial intelligence is that in international law, in order to find responsibility with a state, the act needs to be attributed to a state. And so the question then comes, and this is maybe something a bit more overarching than just space, so just in technology as a whole, can you attribute something to an artificial intelligence? And so that comes from an artificial intelligence. And I think the difference between something that's automatic and something that's autonomous is very, very important. Now, we know that there have been some companies that are trialing, for example, an intelligent refrigerator. So you buy this refrigerator, put it in your home, and what happens is you tell this refrigerator, I would like to lose 2 pounds a week. And I like apples and oranges, and I don't really like red beets, and I really, really don't like carrots. So your fridge says, okay, excellent, I will buy a pound of apples and a pound of oranges this week. And you know what, since you don't like carrots, I'll buy you cucumbers as well. So I buy that, and then so the fridge decides that for me, and the fridge places the order with the supermarket, which then delivers it. But then the fridge makes a mistake, and somehow the fridge then says, instead of having, say, a pound of cucumbers, it buys 100 pounds of cucumbers, and suddenly I have a huge amount of cucumbers at home. And I look at it and say, no, I reject this order because I did not make it. This was not right. And of course, the supermarket comes and says, no, we got this order from your fridge. that you said we could take orders from. So when there's an error that was created by an artificial intelligence entity, what do we do? Now, of course, the contract, if it's drawn up by a good lawyer, would simply say sorry, but the errors on the consumer side, so consumer takes it. Or if it's from the supermarket, would say, we're just going to push it out to you. Good luck. There are various different ways of dealing with it. We still don't know exactly how to deal with it. But I think that the huge difference is whether something's automatic. So I program it. So the difference is that, for example, if I program it and I enter the human error and I say 100 pounds, that's different than if the fridge itself makes a mistake and enters 100 pounds. Now, of course, you can trace it always back to a code. So the thing's coded to do something, it's coded to learn. And at some point, maybe the fridge thinks, okay, you know what, you like apples and oranges, but have you tried grapes? Grapes are wonderful. They taste amazing. So the fridge orders 50 pounds of grapes from me, and I really don't like grapes. Can I refuse that order? Can I repudiate that contract? To what extent can we stretch the limits of contract law? Can we just put something on it as a band-aid, or do we need to think about it in a different from a different point of view? And I think that also will apply to outer space. And that is also something that we need to think about in terms of international responsibility. Now, imagine you have an LLM model that does, think about things like space debris, how to clean space debris up. So, it starts to clean things up and it decides which satellite it wants to clean up, which one is functioning, which one is not. And say he makes a mistake and it then disables a functioning satellite. Who's responsible for that? Those are kind of issues that I think will arise in the near future if it hasn't already.
Very interesting.
Now both my devices are working, so sorry about that. So I am mindful of the time. I think we've got two questions here. We were also going to share with you another component of space law, which is very interesting, which is cooperation in due regard. And maybe we can come to that. I want to be mindful of the questions as well. And maybe we could try to weave this in some way. But we've got two questions here from David and from Sean. The first question, if two commercial satellites crash into each other and there is a dispute, how are relevant state actors involved in the dispute resolution? Are the states parties to the dispute in conjunction with the private actors? So, Professor, initial thoughts on this?
I'm a lawyer, I'm afraid. There's several questions here, I think. So two commercial satellites crash into each other and there is a dispute. So the important thing then basically is, I'm assuming that the question is that they crash into each other in outer space. That matters, whether it's on outer space or on Earth. And the reason is because in airspace and on Earth, it is strict liability regardless of fault. In outer space, there is fault-based liability. So that's two different kinds of regime. Now, if you have two commercial satellites that crash into each other, there's a dispute. The question is, what's a dispute? Is it obvious who was at fault, or was it not obvious who was at fault? But to the pertinent question as to which relevant state actors, or at least how would the relevant state actors be involved? The mechanism is this: states that are parties to the Outer Space Treaty are under the obligation to authorize and continuously supervise any sort of space activities by their nationals. And the way the way states do that is to usually have a certification and a licensing regime for every space company, every entity that engages in space activities, which are their nationals, so either seated in their countries or operating in their territories and so on. And so how are they involved? Usually the licensing framework would provide for indemnity, would provide for indemnification and for insurance. But where it's not covered, the state would actually cover the rest of it. So that's how they would be involved. Imagine it's the limit of the insurance is, say, 500 million. The damage cost was $1 billion. The makeup to the next 500 million to get to the billion is basically what is in dispute. Then a matter of who's at fault, and of course states would then get involved in that dispute to kind of see how would that work. Now, the next question, are the states parties to the dispute in conjunction with the private actors? They could be, but generally, if they follow the liability convention, the claims commission is only state to state. That's one of the biggest gaps in the liability convention that's been commented upon. But that's where arbitration comes into play. And that's where the PCA, for example, has optional rules in relation to arbitration, where you can have mixed arbitration. You can have interstate, you can have various different kinds of arbitration. And that's where arbitration, I think, one of the reasons why it is so popular for space disputes.
And just to add to that, the PCA outer space rules, right? So I think there is also a question of privity, right? I mean, if you've got two satellites, two operators that have no relationship to each other, there's no contract necessarily. So of course you can, depending on, who did what. And I think there'll be actual, obviously two satellites are crashing in space. I think literally everyone in space will be affected by it. But just the fact, how can you resolve that dispute? The PCA outer space rules do not require, if I remember correctly, there to be a contractual relationship. So I think that was actually really smart to have that option. It's an option. Those are optional rules that two parties can agree to after the fact, right? So that's just kind of an interesting tidbit, because not everyone in space has a relationship with each other, which is why like the state regime makes a lot of sense, right? The other option is, if you're a satellite manufacturer or operator and you have been hit by someone, you will go to your state to then start the commission that Professor mentioned. So that ends up being a state to state kind of dispute resolution. The second question, from Sean, whether we think states will recognize or use decentralized online dispute resolution platforms based in or focused on the field of space, or will we see state-led institutions as we have seen for the last 100 years, so that shared sovereign control remains?
I think perhaps I don't want to sound cynical saying this, but if you start off the question saying whether states will recognize, well, I think recognition and use are two different things, basically. So let's start with use. Whether states would use such decentralized online dispute resolution platforms, I think until we can prove, or at least really prove beyond a doubt, the robustness of such systems, states tend to be quite conservative, I would say, in relation to disputes that have a sovereign component, in particular with space, because it does have a strategic component as well. So I think that's something that will depend upon the proof of the robustness of that system. Now, whether they would recognize a dispute settlement an award or a judgment from such thing, it's actually now being studied by several jurisdictions. So, for example, Claros, and they have like various different ways of this online decentralized platforms for dispute resolution, where tokens can choose your arbitrator and how that arbitration is being conducted. The question, of course, is that an arbitral award, speaking quite frankly, arbitral awards are useless if they cannot be enforced. So it's great to have a piece of paper, but if that paper cannot be enforced, that's all that remains. It is a piece of paper. You need a jurisdiction right now, at least, to say, yes, we will enforce it. And under the New York Convention, for example, you can get something out of this piece of paper. Because of the inherently international and cross-border kinds of disputes we see in space, this recognition problem will be a specific issue that needs to be addressed. And so I think the question then for the arbitration community would be whether these decentralized online platforms will one day, or at least will at some point be something that can also apply under the New York Convention. So if you need to enforce it, to recognize and enforce it. So I think that is the matter. But space has and will always have, at least in the near future, a strategic political component, and that also means that. I think progress in allowing other actors in terms of dispute settlement probably will move a little slower than in other fields.
Thank you very much. That's there's a lot to think about here. So I'm mindful of the fact that we're 3 minutes over. I don't know if there are any other questions. Obviously, there are lots of, we didn't even get to the third topic of due regard, which is something we did want to talk about because there's a lot of interesting things happening there. But I wanted to just give the opportunity to, if anyone else had a question, there's a lot to think about. I think just there's space and there's, technology, and then there's disputes. And to me, the three components actually, this is a great way to start the day. I feel very.
Hello, can you hear me?
Yes, I can.
Yeah, I'm Les Schiefelbein, and I have a question for Gérardine. Since you just mentioned strategic political aspects, a small number of of states, although they are the larger ones in the global community, the US, China, USSR, and India, have launched for strategic geopolitical purposes anti-satellite weapons, where they have blown up their own satellites in space, caused hundreds of thousands of objects of space debris. Since this is a strategic national security issue, where do you think liability, if any, would fall under the Space Convention, if at all?
Thank you for the question, Les, and it's lovely to meet you. Thank you for joining us. The matter I think here is, I mean, the first question is it illegal? Does it give rise to an internationally wrongful act if an anti-satellite weapon is used against a satellite? Obviously, if a weapon is used against somebody else's satellite, you can, of course, say that there's an internationally wrongful act because you've gone and destroyed somebody else's property or somebody else's satellite. But what if you just test it on your own satellite? So in some cases, we've had already some years ago the test of an anti-satellite weapon against the state's own satellite, just to, I suppose, flex a muscle and say, look, we can do this, and show the world that they can. I think there, and this is what Viva wanted to talk about, there is an article in the Outer Space Treaty, and it's Article 9, which has to do with due regard. Now, the interesting thing is this: space law is not the newest field of international law. The youngest field of international law today, actually, is international environmental law, which coalesced, as you will know, in 1982 with the Rio Declaration. So the 1967 Outer Space Treaty predates the coalescence with international environmental law. However, in the Space Treaty, there is a specific obligation to take into account, or at least give due regard, to the interests of other state parties. And one could argue that the use of an anti-satellite weapon against a satellite, whether your own or others, is in breach of this obligation for the reason of the space debris, as you say, Les, very correctly say, the amount of space debris that is caused at the instant of the act, but due to the Kessler effect, thereafter following the act as well. Now, having space debris in any kind of orbit, and in particular low Earth orbit, is in general not good for anybody in the international community, any individual or any state. It makes it difficult to launch. It does create issues in terms of the safety of satellites, the safety of our astronauts, the safety of space stations. And also, you have this kind of very Wall-E effect, where you see, how do we get through from Earth into outer space? You've got to smash right through this whole orbiting, mass of thing. So you could argue, of course, that there is that. So far, we have seen, of course, quite a lot of official statements in relation to these tests and these use of anti-satellite weapons. We haven't seen yet a claim brought under the Liability Convention. And again, it could very well be due to that strategic political concern that started the test to begin with.
Thank you.
Thank you.
I think it'll also be very interesting to see what happens when a private actor is affected by that state conduct, because the private actor trying to assign responsibility, liability, either will have to go to their state to advocate on their behalf, or will have to go to the courts of that country, I think. So you've got another, what is the hook as a private actor operating in space based on, state acts, right? So there's more there as well. But thank you for that question. I don't know if there are any other questions. Again, being mindful of people's time, we've gone a little bit over. If not, I will thank Professor Escolar very much for making time to be with us today. I know things have been very busy in your day job. Space person by night and diplomat negotiator by day. Thank you very much, David. Thank you very much, Sean. Thank you very much, ArbTech, for having us and be able to talk about space and technology and just disputes, which, like I said, and thank you everyone for coming out as well. I hope you have a nice day and a happy weekend.
Thank you
David.
so much. Thank you for having me. And if you have any questions, just please do reach out. My name is particularly difficult to spell, but if you do get it right, I'm also available on LinkedIn. So it's probably the easiest way to get hold of me on social media. But thank you for spending your time with me and with ArbTech today. Thank you so much, ArbTech, David, Sean, and Viva for having me.
Well, on behalf of ArbTech, I just want to quickly thank both of you for what this fascinating conversation. I can see that I'm already going to try and convince you two to do a part 2 on this, because I have so many questions. I think there's so many more topics on this that you can probably talk about. But this has been absolutely fascinating and very, very enjoyable. So thank you for taking the time to share your unique insights on this. And for everyone else, thank you for joining us today. If you'd like to rewatch or recommend this session to any one of your colleagues or friends, we will be posting this on YouTube, our YouTube channel, in due course, so you can find it there. So thank you again, everyone. Have a good weekend. Take care.